Tonight, the Supreme Court of the United States has delivered a unanimous 9-0 decision, an extraordinary moment in a divided nation. In a time when consensus is rare, all 9 justices have spoken with one voice, sending shockwaves across the country. The eyes of millions are fixed on the court, waiting to see how this decision will shape the future. This ruling redraws the boundaries of digital privacy, affecting anyone who owns a smartphone or uses the internet. Whether you're texting a friend, shopping online, or simply browsing social media, the implications are profound. Our daily lives are intertwined with technology, and tonight, the rules have changed for everyone: students, parents, workers, and business owners alike. The case at the center, the government's ability to access your digital data without a warrant, has sparked fierce debate for years. At stake is the balance between national security and personal privacy, a question that has grown more urgent as our lives move increasingly online. For years, technology outpaced the law, but today, the court sent a clear message: our digital lives deserve constitutional protection. The justices recognize that the devices we carry are not just tools, but extensions of ourselves, holding our most private thoughts, memories, and communications. The justices, from all backgrounds, agreed: your digital footprint is as private as your home. This landmark decision bridges generations and ideologies, affirming that privacy is a fundamental right, no matter how technology evolves. This is a rare moment of unity, affirming that the Fourth Amendment must evolve with technology. The Constitution, written centuries ago, now extends its shield over the digital world, protecting citizens in ways the founders could never have imagined. We'll break down what this means for your privacy, your rights, and the future of digital freedom in America. How will law enforcement adapt? What new responsibilities do tech companies face? And what can you do to protect your own data in this new era? Let's dive into the case, the decision, and the new era it ushers in. The story of digital privacy in America has just turned a new page, and its impact will be felt for generations to come. To grasp the impact of today's decision, we need to understand the Supreme Court's role. As the final interpreter of the Constitution, the court's rulings shape the law for the entire nation. 9 justices, appointed for life, bring diverse philosophies, yet their decisions set binding precedents. The court doesn't make or enforce laws. It decides if government actions align with constitutional principles. Unanimous decisions like today's are rare, signaling a fundamental constitutional truth. This ruling on digital privacy shows that all 9 justices agree. The right to be secure from government intrusion must keep pace with technology. The decision's unity gives it exceptional legal and moral weight. It's a moment that transcends politics, reaffirming privacy as a core American value. Now, let's see how this case made its way to the highest court. The case began 4 years ago, not with a crime, but with a quiet shift in how the government accessed information. It wasn't a dramatic raid or a high-profile arrest that set things in motion. Instead, it was a series of routine data requests that would soon spark a national debate about the boundaries of privacy in the digital era. The government started collecting vast amounts of digital data from ordinary Americans, all without obtaining individual warrants. This included everything from location histories to search queries, quietly gathered behind the scenes. Relying on the controversial third-party data directive, federal investigators compelled major tech companies to hand over user data, location, searches, call logs, and more, without ever needing to show probable cause to a judge. The government's legal team argued that this data wasn't truly private, pointing to the decades-old third-party doctrine, which says information shared with a company isn't protected by the Constitution's privacy guarantees. But the Digital Privacy Alliance, a coalition of civil liberties groups and leading tech companies, pushed back. They argued that the sheer volume and sensitivity of modern digital data made it fundamentally different from anything the courts had seen before, and that it deserved robust constitutional protection. Initially, a federal district court sided with the government, upholding the warrantless data collection. But on appeal, the Ninth Circuit reversed that decision, declaring that such sweeping access to digital records constituted a search under the Fourth Amendment. This sharp split among federal courts created uncertainty nationwide and set the stage for a landmark Supreme Court review. The central question: does the government need a warrant to access the intimate details of your digital life? Your movements, your conversations, your private searches? The stakes could not be higher. At issue is nothing less than the future of privacy in the digital age, affecting millions of Americans who rely on technology every day. Recognizing the gravity of the issue, the Supreme Court agreed to hear the case and settle the debate once and for all. Now, the nation watched as the justices weighed the constitutional questions at the heart of United States versus Digital Privacy Alliance. The Fourth Amendment protects against unreasonable searches and seizures, but does it cover your digital data? The government claimed that using online services means you give up privacy, since your data becomes a company's business record. They warned that requiring warrants would hinder crime fighting. The Digital Privacy Alliance countered, digital life isn't optional, and your phone is an extension of your private space. They argued that old precedents don't fit today's technology, and that digital data deserves the same protection as your home. The court had to decide, stick with outdated doctrine, or recognize the realities of modern life. The answer would redefine privacy for a generation. The Supreme Court's answer was clear and unanimous. When it comes to your digital data, the government must first obtain a warrant. This landmark decision sent a powerful message. The privacy protections enshrined in the Constitution are not relics of the past, but living principles that adapt to new technology. The majority opinion made it clear that the third-party doctrine, which once allowed the government to access information shared with others, simply doesn't apply to the vast and deeply personal information stored on our modern devices. Our smartphones, tablets, and computers are not just tools, they are repositories of our lives. Americans, the court affirmed, have a reasonable expectation of privacy in their digital records, just as they do in the privacy of their own homes. The digital age hasn't changed the fundamental right to keep personal matters private. It has only made that right more vital. By limiting old precedents, the court recognized that a single smartphone can now hold a lifetime's worth of photos, messages, documents, and memories. The law must keep pace with technology, and the justices acknowledged that our digital footprints deserve the same protection as our physical spaces. Justices from both conservative and liberal backgrounds wrote concurring opinions, each highlighting the dangers of unchecked government surveillance. They emphasized the original intent of the Fourth Amendment, to shield citizens from unreasonable searches and to preserve the balance of power between the people and the state. This decision wasn't about partisan politics. It was about upholding a core American right that transcends ideology. The ruling reaffirmed that privacy is a fundamental value shared by all Americans, regardless of background or belief. Importantly, the ruling doesn't bar government access to digital information altogether. Instead, it sets a clear standard. Law enforcement must obtain a warrant and demonstrate probable cause before intruding on someone's digital life. This ensures both public safety and individual liberty. The court made it clear, efficiency and convenience for the government can never trump the constitutional rights of the people. Protecting privacy sometimes requires extra steps, but those steps are essential to a free society. The message is unmistakable. In the digital era, your privacy is now firmly protected by the Constitution. The Supreme Court's decision stands as a modern safeguard for our most personal information, ensuring that our rights endure in a rapidly changing world. The decision sent shockwaves through Washington, forcing lawmakers to rethink surveillance laws. With all 9 justices in agreement, political leaders quickly shifted to support stronger privacy protections. Congress must now rewrite parts of the Patriot Act and other laws to comply with the new standard. Federal agencies must halt warrantless data collection immediately, triggering a major operational overhaul. Privacy is now a central issue for upcoming elections, with candidates pressed to take clear positions. Advocacy groups are mobilizing to ensure new laws reflect the court's principles. The political landscape and the debate over privacy has changed forever. The ruling has huge implications for tech companies, giving them a Supreme Court-backed mandate to protect user data. Tech firms must now require warrants for government data requests, updating policies and protocols. This clarity boosts their credibility with users and investors, and aligns U.S. privacy standards with those in Europe. The decision may ease international tensions and help American companies abroad. But it also raises new questions about corporate data collection for commercial purposes. The court's strong stance on privacy could spark future lawsuits and legislation targeting how companies use personal data. The economic and ethical debate over data is just beginning. The digital landscape is being redrawn. For deeper insight, we spoke with Professor Lawrence Tribe, a leading constitutional scholar. He called the decision a landmark, elevating privacy to a core principle for the digital era. Tribe explained that the court rejected the outdated third-party doctrine, affirming that digital life isn't optional and privacy must be protected. The ruling shifts the burden to the government. Privacy is the default, and searches require judicial approval. He emphasized that Congress must now create new laws that respect this standard while addressing law enforcement needs. Tribe praised the court's unity, saying it shows the Supreme Court can still defend fundamental rights above politics. This is a victory for privacy, the rule of law, and American democracy. The work continues, but the foundation is set. What does this mean for you? Your digital life is now more private and secure from government intrusion. The government can't demand your data from tech companies without a warrant. Your phone is now protected like your home. This is a real shift in your rights as an American. But the fight for privacy isn't over. New laws and policies are coming, and your engagement matters. Stay informed, read privacy policies, and talk to your representatives. The Supreme Court has set a new baseline. Digital privacy is a constitutional right. It's up to all of us to defend it. Tonight, the court spoke with one voice for liberty in the digital age. Even in a divided nation, some values unite us. The future of privacy starts now.